Hi, this is Noah Weisberg. If you don't know me, I co-founded Kira Systems back in 2011 with Dr. Alexander Hudek. I was its CEO until we sold it to Latera in 2021. And since then, I've been the CEO of Zuva, which is also a contract analysis business. So I've been doing contract analysis for a fair while. Like a lot of people in legal tech, I looked a bunch at the recent Val's AI, Gen AI evaluation of four vendors. And I was really super interested in the data extraction section, and especially one bit of color they gave us on the data extraction section around a MFN clause that three of the four vendors studied missed. And I decided to look more into it. And that's what we're going to talk about in this video. In the data extraction bit of the Val study, they looked at 30 questions over 29 documents with 1 to 7 documents provided as context. It's kind of unclear to me if that means they asked all questions across all 29 documents, but my sense from reading later is that it more was they asked some of the questions to 1 to 7 documents, which kind of makes more sense with the way they describe some stuff. And what they found in general was that the systems performed pretty well at that. However, they provided a little bit of color on one specific question that they asked, which was a most favored nation clause and whether these systems could find a most favored nation clause. And that's what we're going to look at here. I will say the systems performing pretty well on most stuff is actually not that surprising to me. Little story from the very early, like 2011 days of our systems. We were working with some earlier generations of technology. Back then, the first clause we started on trying to identify was governing law. And I think I provided 20 examples, and Alex built some machine learning, and we tried it out, and the system worked great. And we were like, oh, this is going to be so easy. Like, a year later, 2 years later, as we still struggled with the problem, we no longer felt that it was easy. So as we started to put harder clauses in, so I think after governing law, we went to assignment, and then from assignment, we went to change of control. And like the gradation between governing law and assignment was like it's definitely harder to find an assignment clause than a governing law clause, but still relatively easy compared to change of control. MFN is a clause that I would put in kind of the same category as change of control, like also maybe probably a little bit easier in our experience than change of control, but definitely something that doesn't appear in every contract and can be trickily phrased sometimes. Not nearly as bad as I would say exclusivity or non-compete, but definitely can be tricky. The problem with MFN, though, is that it's really a clause you can't afford to miss if you're looking for it. So especially in the context of mergers and acquisitions due diligence, which, by the way, is what I was an M&A lawyer at Wellgotshall before I started co-founded Kira, and we do a fair bit of diligence in that role, and you just could not miss something like an MFN in there. An MFN is a clause that says that you won't give anyone else any better terms than you're given to the contract counterparty. It could be pricing terms, that could be other terms. But what it means is that if you put an MFN clause into a contract and then later on you feel like cutting someone else a better deal, you have to go back and give that party with whom you have the MFN the same deal. And so you can see that pops up here in this Global Logic Master Services Agreement. So if we look at it, here's the clause, the bit of the clause that really matters. Global Logic will provide the client access to its personnel no less favorable than what it provides to any other customer. So that's saying if anyone else becomes a Global Logic customer, that this client's not going to be worse treated with regard to them. So pretty standard MFN clause in my view, but something that in the course of diligence could be really bad. The reason it could be really bad is depending on how sort of global logic is defined in the contract, this obligation could apply to someone who acquired global logic. And so it could mean that the global logic got acquired by like a really big business like Accenture or IBM, that those businesses could, again, depending on how the contract's phrased, be on the hook for this obligation to that same client, but within the context of a much larger business, which would be really bad. So good reason a lot of companies try to avoid MFNs, and it's a big deal to find them in diligence. I was really interested to see how the Gen AI tools would perform on this. Over the years, I've heard a lot of anecdotes about their performance at contract extraction, but it's not like they have free trials or they come and give me demos, so I haven't been able to evaluate the sort of anecdotal stuff and so I was pretty interested to see how they performed on this. And it turns out the answer is not well. And that's like really sort of shocking if you do plan on using these systems in due diligence, especially since I would say the Val situation was probably like an easier situation than you'd face in a lot of real life due diligence examples, because it's like one or two as opposed to hundreds or thousands of agreements where, because of context windows and the like, those can potentially be harder on Gen AI systems. Also, my guess is the document was provided in pretty clean form in due diligence. You can have documents that are provided in all sorts of form, including especially the form of poorly scanned OCR documents. Anyways, checking out the results, CoCounsel found the right text, which is great. Vincent missed it. Harvey threw a false positive, and Oliver missed it. So pretty surprising results. I decided as a first step to take this same document. Someone sent me a link to the document, and I took the document and I converted it into PDF and Word and shortened it down and did all sorts of different versions of it. And I decided I'd try it in Zuva. Zuva is our UI-based contract analysis tool, and I thought it would just be interesting to see whether maybe there was something trickier than it looked in this MFN clause. So I grabbed the MSA terms and dropped them into Zuva. And Zuva finds a whole lot of stuff. So what you have to do in Zuva, like we find 1,400 or so data points out of the box. And so what you have to do with Zuva is just add a workflow. I know the M&A due diligence workflow has MFN, so I'll just apply that workflow. The reason there are 3 different versions of this is, as we'll discuss a little bit later, I then, after doing this, did some testing on GPT-4o to see how it would perform at this. And it had some troubles with some versions of this document, so I decided to kind of create some easier versions of it. So the original document, which is here, I first converted it into a PDF. It's like a 79-page PDF with dual columns, which again is not that weird in the scheme of things, and drop those in. So I have like a full longer version and some shorter versions. Let's just look through and see how the system does. So I'm going to click in here in this doc version, to make things easier on the LLMs, because I wasn't seeing great performance when I tried earlier on GPT. I cut it down to be a little bit shorter. So this is just the terms part of the Global Logic MSA. It is the part that has the MFN in it, 16 pages. So if I kick down, you can see this is all stuff that are standard M&A due diligence workflow finds. And if I get to MFN, most favored nation, I see that the system has found this. Great. And remember, I put in 2 other versions. Just really quickly, we can look at those. So here's the 79-page version. It's processed, kick down to MFN. Again, the system has found it without any issue. And finally, if I look at the same one where I just shortened down the PDF version, go down there, and again, unsurprisingly, since I found it 2 other times, Zuva performed here. One kind of plus of our technology is it tends to be pretty consistent at finding stuff, besides being pretty good at finding stuff that's in there. So basically, the 3 tools missed MFN clause, but Zuva found it. Now, I might have stopped there, and I was going to stop there. But then I noticed a post from Arthur Souza Rodriguez, who was involved in the testing, and he has kind of put up a lot of stuff. And his thing is that the way the text was put in the systems, the MFN clause might not have been visible to some of the systems. I thought that was plausible, so I decided to try this out on GPT and saw something interesting. So my sense is from reading around that a lot of these systems are heavily based on GPT-4o. Some of them may use some other models like Gemini in them as well. But I thought it would be really interesting to test this particular prompt and this particular query in GPT-4o. All right, so I'm going to do that. I will then take the full version of the document, drop it in, just wait for it to upload, and we'll see what we find. Now, this is really interesting. So here, GPT-4o says there are no direct or explicit references to MFN clauses in the visible portions of the document. Interestingly, this is where when I checked the same document multiple different ways earlier today, this was the answer I got kind of multiple different times. Interestingly, in the last half hour or so when I've been testing it, I've been getting different results where now GPT does a nice thing where it says there are some additional points that could include it. So annual review and pricing, additions, client rights to review fees, assignment of personnel. So here it actually does find the specific thing and it does kind of figure out that this is kind of like an MFN. It thinks it's not because it's thinking about MFN in one specific way when in fact MFN can be lots of different ways. Like in fact, MFN need not be about pricing. And in fact, in the fund formation realm, like there's often side letters between limited partners and the fund that give those limited partners special rights, most favored nation rights sometimes. But here they've kind of found and given a more exhaustive review. Interestingly, when I looked through earlier today and even provided the full text of the document because I was having trouble with the uploaded versions when I tried them earlier today, it said, thank you for providing it. There are no references to most favored nation clauses or language typically associated with MFN provisions in this document. So, and here it kind of defined MFN to suggest that it should have found the one that was missed. So it's kind of interesting to me that the system has kind of changed its behavior over the course of the day. But I guess that shows positive adaptability of a Gen AI system. If anyone is interested in trying this out for yourself, you can with Zuva Analyze. It's really easy to go to Zuva.ai and you can sign up for free and just try out Zuva yourself. And I encourage you to do so and try and see if this document works, if other documents you'd like work. Generally, we try to build our AI so that it's pretty reliable, number one, and so that a person using it can get to the right result really quickly, even though the system will sometimes have false positives and the like. So that's one thing you can do. The Global Logic Master Services Agreement is available on Edgar, and I'll try to put it in the notes, and you should check this out. But I think to me, as someone who's reviewed a lot of contracts, I found this sort of extract and sort of highlight in the Bell study kind of surprising and shocking, and definitely raised questions for me as to how comfortable I would feel using one of these systems right now on a large scale contract review project where I needed the answers kind of accurate. That said, technology is always getting better and maybe things will change over time. And maybe there were reasons for the way the test was run, though to me, a lot of those reasons cut in favor of the AI vendors. And my guess is that real life contract review is probably a lot harder than happened in the Val study. So I'm kind of disinclined to be super generous with the systems. I think this is just based on a lot of years of having been an M&A lawyer and having then helped a lot of M&A lawyers. I find there's not a lot of sympathy for missing clauses. But again, these systems look better. And thanks for making it to the end. Hope you have a great day.